Thank you, Stuart. The first question is, because there's no obligation for farmers to put up their land, if they even can, if they even could put up their land, if they even own their land, which most of them don't, but because there's no obligation under the contract, therefore I would presume that none of the 5.5 million megalitres of water is secured by property?
I'll take this one, if that's all right. So the security provisions, which we've talked about in here already, are a letter of credit for 2 years. The letter of credit is a really good form of security because it will need to be backed with the banks. The banks will need to have an asset backing from that water user.
That's not my question, sorry.
I know.
I want to address that.
Yeah, okay.
There is no land securing this lot.
So the provisions around taking that letter of credit support say that that's what it will be taken unless an agreement is otherwise reached with council. So that's where you could get land in if you wanted to.
My question is, any of the 5.5 million megalitres cubes of water, is any of it secured by land? Yes or no?
At this present point in time, I don't even know how many water user agreements are signed up. But if you're saying that's what the 5.5 is,
I think you'd have to ask HBRC that question.
Well, actually, with all due respect, I'm asking our lawyer.
And they're saying they don't know, they don't have the information.
Okay. So my second question, as our lawyer and our advisor in legal matters, are you happy that a farmer can have a farming company and he goes broke or wants to leave or does whatever he wants to do over his farm, which is a trust, so he doesn't own his land, which is most of the case, and so he ceases operation for whatever reason, and we get 2 years letter of credit, we get 2 years, that's all we get. So he says, I'm out of here, and we get 2 years. Are you happy as our solicitor that that is sufficient security?
Shall I take that one? I think there is considerable comfort in having a 2-year window. We're not dealing with a dam that has 8 water users. We're dealing with a dam that has potentially hundreds of water users. And the ability to then, in the circumstances of a liquidation, turn around and allocate that water to other people who will use it and pay for it is an important factor. And as I said in my intro, there is considerable comfort derived from the fact that the banks don't have an issue with this. And I suspect from a commercial palatability point of view, if HBRC wanted a belt and braces approach and said, well, we'll have a 2-year LC and we'd like a personal guarantee from all of the farmers right through till they're 80 or 90 years of age, and we want to have a tight mortgage over the land which will sit in priority to the existing first mortgage, etc., nobody would sign up. So I see this as a commercial compromise which gives considerable comfort because of the LC, which is a wonderful tool for enforcement. You can simply go to the bank and ask them to pay up. There is no requirement to issue proceedings. The bank has to come to the party. So from that point of view, yes, we are comfortable. We talked this uphill and down dale in the office, and we're comfortable with the arrangement where this is a good commercial compromise and it's considerably better than a personal guarantee situation.
Stuart, could you just confirm that LC is letter of credit?
Yes.
Thank you.
Comment to that because I just think that's outrageous. But
Can I follow up that question though? I mean, we're asking you to satisfy our questions and needs and queries and wants, etc. here, but there'll be other investors in this as well. Do you think they would go through a similar process of due diligence that we've gone through with you guys, looking at this? I mean, there'll be many more eyes looking at these set of arrangements yet. Would that be
Absolutely,
fair?
and in the drafting of this, with HBRC and their lawyers, they've looked at it as well. So this is where they've got to in terms of a good balance of enforceability, but flexibility out there for the water users as well.
Other questions?
ask you to pull your microphones out because I think people at the back.
People can't hear you, Councillor Scott. Yeah.
Are having trouble hearing. So if you pull the actual
Oh,
stem of the microphone towards you. I'm sorry, Mr. Chairman. I'm just catching a few.
Few people wondering. Okay, Councillor Bevan.
So I have a couple of questions as well. The first relates to this this 2-year letter of credit. Is it a rolling letter of credit? So, for instance, there's a 35-year contract and you're 5 years into it and you go broke or you walk away, then we're covered for 2 years.
It's rolling,
correct?
so it's from the time of default. There's a 2-year pay-up provision for that
Right.
particular bank.
Okay.
So all of the water users will have to make arrangements with their bankers, backed, I suspect, by land, by way of mortgage or whatever, and possibly guarantee from their end of it. That has to be in place for the duration of the 35 years.
Okay. My second question relates to what happens if the land is sold or the owner or a lease. Let's say you have an arrangement and you can't tell us how many of the water users that are currently signed up, there's 5.6 million cubes, as Councillor Graham said. You're not able to tell us how many of those are actually the landowner and how many of them are not landowner, or so in other words, they're a lessee or whatever who's operating the land.
No.
I want to know what happens if the lessee's term runs out and the owner enters into a new leasing agreement, or if the owner sells the land. What is the status of these agreements when that happens?
The water user agreement is personal to the water user, but there needs to be, in the terms of the water user agreement, needs to be a connection between the water user and the land that's being irrigated. That's made quite clear. In the circumstances where there is a sale of the land or the lease comes to its natural end, then there is the ability to assign that water user right to a third party, and in time for that original water user to be released from liability. So in circumstances where there might be a landowner who has a lessee who's growing a crop, and the lessee says, I don't wish to do this anymore, I'm leaving, I'm going away. In those circumstances, the lessee is not let off the hook, is still obliged to pay for the water take until that assignment to a third party has occurred. And in those circumstances, HBRC can turn around and say, we're happy with the new person and we'll release you from the existing liability.
And there is an obligation on the landowner or the water user in this instance to give notice if they're selling the farm. So they have to give council notice before they do that.
Thank you. No one else? Councillor Belford?
Looking at the water user agreement itself on page 30, there's a provision that reads, and this is relating to this credit support we're talking about, 14.1D, HBRC may at its discretion agree on alternative credit support arrangements with any water user which will, if agreed between the parties, prevail over the requirements of this paragraph 14. My reading of that is basically that HBRC can make any arrangement it wants to make with any water user regarding their credit support.
Well, this does give HBRC the possibility of saying to a particular water user, we're not very comfortable about your backing, we want security over land. So yes, it does give them full discretion. So
So every agreement could have a different set of arrangements as far as the security that Councillor Rex is looking for.
Potentially. And if the water user can't provide an LC from a bank which fits the criteria in terms of credit rating, then it may well be that HBRC can say, what else can you provide us with that gives us the same level of comfort as a 2-year LC, which would be a mortgage and potentially guarantee from the stakeholders of the company or entity that owns the land or is operating the production on the land that requires the irrigation. So I see it as a flexible tool, but yes, HBRC has the ability to say, we'll take alternative security, and I think commercially it's good to have that clause in there.
So the 2-year letter of credit is just a sort of a starting marker.
I see it as a default position. That's what's required. That's what these water users are being asked to provide.
Questions? You have a
Well,
question?
that's just not, it's
Well,
not
hang
a
on,
default position. It's not a default position. That's what they'll go for. That is what exists. Default is something else.
Well, perhaps it's semantic. In my terminology, this agreement says you must provide a 2-year LC.
So that's it.
If a water user is valued by HBRC in terms of uptake, but can't provide an LC, it may be that HBRC will then look at other alternative credit arrangements similar to or better than a 2-year LC.
Thank you.
But there's no requirement in that situation.
Complete discretion on HBRC in that regard can't be dictated by the water user.
Can-
That was my question, sorry, but in the 5.5 million, we don't think there's no default. Okay.
We simply don't know. That's with HBRC.
Councillor Pike.
Yeah, thank you. In your review of the of this water user agreement, did you look at any other water user agreements around the country and benchmark it against that to get
Simple
some
answer,
sort of
no.
comparison?
No.
No.
Councillor Dick. Microphone.
Just like your comment, in the situation where the water storage scheme effectively is a utility undertaking, very similar to a telecommunications company or a power company or even the port. In your experience, would a telecommunication company or a power company be extracting levels of comfort and security in terms of ensuring payment that were of greater effectiveness or of greater effectiveness than this letter of credit arrangement here?
Well, quite often those utility companies have nothing more than the power to switch on and switch off.
Precisely.
So this is, in our estimate, considerably better than the switch on, switch off.
Thank you.
Councillor Scott.
Two questions, if I may. One is related to the question I asked Mr. Skurman. Is it possible for you to answer that around the
FEMP.
integrity of the FEMP?
Could you give me the question again?
The question is, the FEMP is prepared by a suitably qualified land scientist. The degree in which that can be altered or withdrawn from, my understanding, is only if that shows that for the intended use it cannot meet the terms of the consent under the LUC leaching rates.
I think the clause provides that it's actually the water user that prepares the FEMP,
Yeah.
and they may use a professional to do that for them. My understanding is that there are actually templates that HBRC has that can be used for water users depending on what their type of use is. Once you are correct that the minimum requirements of that FEMP are that they must meet the requirements of the RWS consents. So that is the minimum requirement. Agreement has to be reached between the water user and HBRC as to what those FEMPs look like. But once they are done, one would assume that they would be assessed on an annual basis or every few years at least to ensure that they're still compliant with the consents. But that's not actually specifically provided for in the agreement at the moment. That is probably something that will be in the protocols.
Except that in 10.5b there's the provision for annual audit, and that's to be conducted by a suitably qualified independent assessor appointed by the water user and approved by the HBRC group manager. So you've got some external oversight, I think, in terms of the FMP and how it operates.
Once it's up and running.
Mm-hmm.
But it isn't a simple case of deciding, I don't want the water after all, I've changed my mind, I'll just write an FEMP that won't meet the conditions.
There's a good faith element in that they have to come to the party and
Yeah.
present something that's going to be acceptable.
Thank you. Mr Chairman, my other question is a very general one. If you were writing this water agreement, is there anything you would have put in or left out that you think would have made it more watertight?
The answer is, and in my background I said we looked at other things that might be there and whether it was comprehensive. The answer is it's comprehensive, but we had some issues in and around some of the definitions and whether it was comprehensible to the average layperson. We struggled with it, but we've had all of our questions answered and now understand what some of these phrases mean. But we've raised those issues with the drafters.
Thank you. One more question here, or is there anyone else? Well, sorry, Councillor Balfour, you have one more, and then I'd like to get to the recommendation by 10:30 if I could.
One more point of anxiety. So we have 40 million cubes signed up. We have water user agreements on the table. We turn on the bulldozers, start building the dam. Then we have a period of time in which we hope that suitable FEMPs will in fact materialize, because they're not required at this stage. And we have a moving target here in terms of what the substantive parameters are going to be as far as water quality are concerned. Should we have any concern that we would pull the trigger on this project before we are in fact sure that there's a meeting of the minds amongst all parties that these farm plans are going to be satisfactory?
Really, it's a matter of referring back to my answer to a question from Councillor Scott. There is a degree of good faith involved in water users coming to the party with an FEMP that's going to be acceptable to HBRC, bearing in mind the consent parameters and so on. I don't think a water user can fudge that, intentionally fail the exam on FEMP, and if that's the case, then they are in breach. They've signed up as a water user, and HBRC could take some action against them if they didn't exercise that duty of good faith. So from a commercial point of view, there's a great deal of comfort to be derived from that.
One more?
Yeah, thanks, Chief. Well, actually, just going back to the very first question about the 60 million cubic metres with a lower number being at the discretion of HBRC to confirm. You're not quite sure what the date that's referred to as financial close is. Can you take that on notice and come back to us? Unless you found
financial close is is defined. It all refers back to the definition under the project agreement, which is the date that all the conditions precedent are satisfied.
So it is the
under the
31st of
project
March
agreement.
next year.
Well, it's when all the conditions are satisfied. That's what will drive the date, not the date driving the conditions.
Sorry. So when all what conditions are satisfied?
Under the project agreement, the conditions that have been...
So that includes the RWS consents being issued on conditions that are satisfactory to everybody.
There'll be a due diligence requirement in there.
Each of the project documents being in a form that meets requirements, unconditional and satisfied. HBRC being satisfied that it's entered into binding subscription agreements or water user agreements for at least X $1 million of interests. And HBRC confirming to the limited partnership that it's acquired the site interests.
Okay, so it's not actually a date. that
No.
specify?
No, it doesn't talk
No.
about a date.
Right.
There's obviously an imperative to have that date sometime in the near future, but it's talked about in terms of satisfaction of the conditions,
Okay.
rather than a crystal clear date to work to.
Okay, thank you.
So we're done? Yep. Oh, sorry, Councillor Hewitt.
Thank you, Stuart. Lauren. That was good. I particularly enjoyed the clarification around the 60 million QMEGs, which I was wondering about too, so thanks, Councillor Bevan. My question for you is, Liz, is there's quite a misconception in the community around the fact that this water user agreement is a secret agreement. So I'd like to draw attention to the fact that councillors received a copy of this back in August of this year. In my opinion, it's not a secret agreement. It's out with a number of farmers in the community. So I'm wondering what we can do to quell that misconception that it's a secret agreement and potentially nobody has seen it. Because I think it's a troublesome misconception in the community that should be dealt with.
You're right, Councillor. It is out in the public domain because it's been distributed to those who have a particular interest in perhaps becoming a signatory to it. Can I suggest what we might do then is, along with other presentations that we've done in the past around this, that we put up the presentation that Mr. Skirman did today onto the Ruataniwha pages on our website. And rather than the actual document, which even lawyers will find difficult sometimes to interpret, really something that sets out the principles of it, some of the detail around it, but essentially a public friendly version of it. Do it like that. Yeah.
So someone happy to move that we get the recommendations yet? You happy to move, Councillor Dick? We have a seconder. Councillor Scott, you wish to speak?
Well, I'd just like to thank our advisors for their comprehensive briefing, and certainly I'm assured that the agreements provide more than adequate security for payment, and so it's appropriate that we do receive the report and, as the wording says, indicate our satisfaction with it and move on. And the most important thing is for the interests of the Regional Council and HBRC to be covered, and the interests of the water users be similarly satisfied. And I'm very comfortable that position has been reached, and try to inflict more onerous conditions on security and that sort of thing would simply be counterproductive. It is the sort of thing that opponents of the project no doubt may wish to advocate, but there is no need. Thank you.
Seconder.
Chairman, I would like to thank our two legal representatives here for their very clear presentation and answering of the questions around this. I think that while they have raised some questions around the comprehensibility, they've certainly given a huge assurance around the comprehensiveness and the appropriateness of the measures in there. They are our legal advisors. This is commercial law that we're talking about, and I think that the actual motion refers to the fact that we are satisfied, receives and is satisfied with the legal review, and I am certainly very satisfied with the answers that we have had today, that this is a water use agreement that gives us surety of financial cover and cover as far as accepting the ability to take up that water goes. So thank you for your views this morning, and it's certainly given me comfort to hear it.
Other speakers? Councillor Belford.
I've not been given the security I was looking for with respect to the environmental aspects of this. To me, it would be more prudent to have 2 steps completed here rather than 1 before we actually begin the process of physically building this dam. The 2 steps being a signed water user agreement, and then secondly, a signed agreement as to how the environmental mitigation was going to be handled by the irrigators involved. We have, in other discussions around this table, been understanding how problematic it's going to be to meet the likely conditions that will be put on this project from an environmental standpoint, but yet you're telling us we can be satisfied that, don't worry, over a 2 or 3 year period while all of this is percolating, trust that these these FEMPs are going to adequately provide for the results that we need to see on the water quality aspect of this. And while that is all percolating along, we're going to be merrily spending $300 million of ratepayer money building a dam. So I don't see that this agreement and the way it's structured gives us adequate security on the environmental side of this at all.
Just for the record, there's not $300 million worth of ratepayer money. Councillor Graham.
No, it's 80. It's a substantial amount of money, nevertheless. Oh, sorry, yeah. Well, the money that I'm responsible for is 80, and I guess it's obvious that I'm still uncomfortable with the securities in the agreement. I think they're soft. Dare I say that will be affecting investor attitude and response, because I think they will think they're soft as well. The comparison with utilities is interesting and convenient, but I would be more interested in comparing this and securing our $80 million investment with a building. If we were to buy a building, and if you try and lease a building in Napier today, you will find that the securities are much tougher than a 2-year LC. And I think, because I've been on both sides of that coin, and I would think that's a much better comparison for us. Just want to talk about the secrecy. There is a perception of that the agreement's a secret, and that is the problem. That is the problem of having something secret in the first place. Because once it's secret in the first place, it's very difficult to then go out and tell people that it's not secret. So, you know, if you don't play those silly games in the first place, you don't get into this kind of problem which we've got now, and there possibly is a perception that the agreements are still secret, which of course they're not anymore, but they were once. So, yeah, I guess, and just rounding up, I'm very unhappy about security in terms of the investment of $80 million of ratepayers' money.
Councillor Hewitt. Then I'll ask the mover to sum up, and we'll go to morning tea.
Okay, I'm just speaking in support of receiving the motion and being satisfied with the legal review. And Stuart, in particular, I'll take your words. You've provided us with confidence that we have a comprehensive and commercially workable contract on which Council and HBRC can rely on. So thank you.
Yeah, just briefly, I just want to thank you very much. You've certainly given me a level of comfort on the water user agreement, and I also just wanted to say that I believe that farmers, in going into this, they're going in there with their eyes wide open. I don't underestimate their intelligence in doing due diligence actually on what they have to actually achieve and what they want to achieve. So I think that is certainly good news anyway. Thank you.
Wish to sum up?
Nothing to add.
Nothing to add. I'll put the motion. All those in favour, please say aye. Aye. Contrary, no. Carried. Thank you.